not for
Yeah.
everyone.
He can't make it this time, but next week he can do it. So Glenn's going to talk to us today.
What we're going to talk about is I have two constitutional challenges that are part of this lawsuit, and I've also got how I'm dealing with the filing fees, and they also give you a letter telling you you're supposed to do electronic filing. So my response to that too, and last time it was like crickets after I did that. Never heard another word about electronic filing, and so we'll see what happens. But and if necessary, I'm going to send them 400 grains of long grain rice. So we'll see. So the Ken's long grain rice remedy is my next step if this one doesn't work. And see, they won't issue summonses until the filing fee is paid. And so I went down there yesterday to get some summonses, and they said, and that's when they came up the same day. The same day there was an order of deficiency filed the same day about the filing fee. So anyways.
Hey, Glenn, you ready to get started?
Yeah, I am. Yeah.
You want the microphone?
You can, but
Hey, Lily, did you meet Lucy?
I just did, yeah.
Okay.
Okay, good.
Steve's going to read scriptures, and then we'll get started. Here you go, Steve.
so you're not going to see my screen on there?
Unless we put the camera on it.
Okay.
Recording in
Here's the
progress.
camera right here.
Oh,
Hello,
Thanks, good.
today is November 25th. I'll be reading from Proverbs.
well, it's not coming out very
25.
good.
These also are proper to Solomon, which men of Hezekiah, king of Judah, copied. It is the glory of God to conceal a matter, but the glory of kings is to search out a matter. As the heavens for height and the earth for depth, so the heart of kings is unsearchable. Take away the dross from silver, and it will go into the silversmith for jewelry. Take away the wicked from before the king, and his throne will be established in righteousness. Do not exalt yourself in the presence of the king, and do not stand in the place of the great, for it is better that he say to you, come up here, than that you should be put lower in the presence of the prince, whom your eyes have seen. Do not go hastily to court. What will you do in the end when your neighbor has put you to shame? Debate your case with your neighbor. Do not disclose a secret to another, lest he who hears it is your shame, and your reputation be ruined. A word fitly spoken is like apples of gold in the settings of silver, like an earring of gold and an ornament of fine gold. It is a rebuker to an obedient ear. Let the cold of snow in time of harvest. Like the cold of snow in time of harvest, it is a faithful messenger to those who sent him, for he refreshes the souls of his masters. Whoever falsely boasts of giving is like clouds and wind without rain. By long forbearance a ruler is persuaded, and a gentle tongue breaks a bone. Have you found honey? Eat only as much as you need, lest you be filled with it and vomit. Seldom set foot in your neighbor's house, but come of you and hate you. A man who is false witness against his brother is like a club, a sword, and a sharp arrow. Confidence is an unfaithful man in time of trouble. It's like a bad tooth and a foot out of joint. Like one who takes away a garment in cold weather, and like vinegar on soda. is one who sings songs to a heavy heart. If your enemy is hungry, give him bread to eat, and if he is thirsty, give him water to drink. For so you will be coals of fire on his head, and the Lord will reward you. The north wind brings rain, and a backbiting tongue in angry comment. It is better to dwell in a corner of a housetop than in the house shared with a contemptuous woman. As cold water to a weary soul, so is good news from a far country. A righteous man who falters before the wicked is like a murky spring and a polluted well. It is not good to eat much honey, so to seek one's own glory is not glory. Whoever has no rule over his own spirit is like a city broken down without walls. Also like to be the chapter out of the New Testament.
Okay.
John 15. I am the true vine, and my Father is the vine dresser. Every branch in me that does not bear fruit, he takes away. And every branch that bears fruit, he prunes, that it may bear more fruit. You are already clean because of the word which I have spoken to you. Abide in me, and I in you, as a branch cannot bear fruit of itself unless it abides in the vine. Neither can you unless you abide in me. I am the vine, and you are the branches. He who abides in me, and I in him, bears much fruit, but without me can do nothing. If anyone does not abide in me, he is cast out as a branch and is withered. And they gather them and throw them into the fire. They are burned. If you abide in me, and my words abide in you, you will ask what you desire, and it will be done for you. But this, my Father, is glorified, that you bear much fruit, so you will be my disciples. As the Father loved me, I also have loved you. Abide in my love. If you keep my commandments, you will keep in my love, just as I have kept my Father's commandment, and abide in his love. These things I have spoken to you, that my joy may remain in you, that your joy may be full. This is my commandment, that you love one another as I have loved you. Greater love has no man than this, that to lay down his own life for his friend. You are my friends, if I do whatever I command you. No longer do I call you servant, for a servant does not know what his master is doing. But I have called you friends, for all things that I heard from my Father, I have made known to you. You did not choose me, but I chose you and appointed you. You should go and bear fruit, and with your fruit should remain, that whatever you ask in my Father in my name, I command you that you love one another. If the world hates you, you know that it hates me before it hated you. If you were of the world loves its own. Yet because you are not of the world, and I choose you out of the world, therefore the world hates you. Remember the word that I said to you. A servant is not greater than his master. If they persecuted me, they will also persecute you. If they keep my word, they will keep yours also. But all these things they will do to you for my name's sake, because they do not know him who sent me. If I had not come and spoken to them, they have no excuse for their sin. He who hates me hates my Father. But if I had not done among them the works which no one else did, they would have no sin. But now they have seen and also hated me and my Father. But this happened that the word might be fulfilled which is written. They hated me without a cause. But when the Helper comes, whom I shall send to you from the Father's Spirit of truth, who proceeds from the Father, he will testify of me. And you also will bear witness, because you have been with me from the beginning.
Good.
With the chapter.
Okay.
that John 15 is strictly Jesus' word. Yeah.
Okay, our presenter has stepped out of the room. But what we're going to do is Jason. Can you tell us a good joke, Jason?
Yes.
Okay.
Hello, mother. Okay, this kid wasn't feeling very good, and he felt kind of sick, and so his mom took him to the doctor, and the doctor, was looking at him, puts him up on the examination table, and it's like going over him and stuff, and he's got a piece of celery from underneath his eye, and he's got a piece of carrot hanging out his nose, and there's a piece of radish, coming from the corner of his eye, and he's like, and the doctor looks at him and says, "I don't think you've been eating right."
Yeah, that's good. I like it. Did you catch that, Lulu? Okay.
We have a very, very special speaker today. And y'all know who he is. He's the bandit from up north. His name is Glenn.
There he is, Glenn. Whoa, what an introduction.
Yeah, I don't know how I can live up to that. Anyways, so I filed a lawsuit over these recent arrests and everything. It's a war crimes complaint. But before we get started with that, I just wanted to cover something real quick that was sent out. This was someone that sent out, this is a Cliff High tweet on X. And says way back in the Bitcoin price projection work 4 years back, he had Bitcoin dropping from 120,000 down to 88,000. It's right now just a little under 88,000. And then moving back up through resistance in stages until there was a conjunction with a period when three governments were dealing with civil rebellion nationally. So what he's saying is Bitcoin's going to go back up through resistance. I don't know if it's all the way to 120,000, but there'll be a period when there's three governments dealing with civil rebellion. Okay. One of these was a major Western republic whose government will completely collapse with politicians trying to flee the country. Gee, that sounds like something that might happen here. Some get caught, and that initiates a whole lot of drama. During that time, Bitcoin works its way back through 128,000 to head to 154. Once through that, during that period of social and economic, and that's all it says. That's all I've got. But anyway, so we were talking about Bitcoin earlier, and all I'm telling you this is because it's an opportunity to, you can make some money. You can make a little bit, or you can, whatever you want to do. But it's also, Cliff High has been pretty good about his data sets have been right, but his timing, he says that this is going to happen. Like I was listening to a video recently that was done in 2014, and he was saying that all of that stuff was going to happen then. Well, it's actually happening now. So he's comparing it though with Bitcoin price, which I think is, probably going to happen the way he said. Anyways, so this is, I filed a war crimes complaint. I've actually had judges send me an order of deficiency. I'd be filing criminal complaints into a case, and the judge, and I'd call them a war crimes complaint. The judge would send me an order of deficiency and tell me I have to file a lawsuit. And so this one's a war crimes complaint. And so this is, as you can see from right here, it's been filed. I filed this yesterday. This is a notice of constitutional challenge about Texas. And so comes now demandant providing notice to anyone interested that the demandant is challenging the constitutionality of Texas joining the Union in 1845 as a violation of this Constitution for the United States of America, Article 4, Section 3, Clause 1, as found in the brief attached, all of which incorporated herein by reference in its entirety. And this is something I'm putting in all of them now, that fails to be dead or lost at sea. I'm putting that in everywhere because that's what they're doing. Is they're failing.
I like that verbiage. It's good.
Yeah, they're putting that, they're presuming you're dead or lost at sea. And in fact, I've even modified that further on some other documents that I'm getting ready to file today. That's a certificate of service. I haven't served a lawsuit on anybody because I haven't got any summonses yet. So, but it will get served. And then I want to, there's another notice of constitutional, this is the brief. So what you do is well, let's go back to this. There's, that's the notice, and then there's a brief attached to it. And this is the brief. President Andrew Jackson officially recognized the Republic of Texas March 3rd, 1837, which is also recognized by France December 25th, 1839, and other nations, including Belgium and the United Kingdom. And the demandant, that's me, has visited the former embassy of the Republic of Texas in Paris, France, that is now being used as a hotel. Yes, and I was there, and I talked to the guy at the front desk. In fact, the fact that the Republic of Texas existed is beyond dispute. This is the Law of Nations by Vattel. So a nation or state has been said from the beginning of this work, a body politic or society of men united together for the purpose of promoting their mutual safety and advantage by their combined strength. For the very design that induces a number of men to form a society which has its common interests is to act in concert if it is necessary that there should be established a public authority to order and direct what is to be done by each in relation to the end of the association. This political authority is the sovereignty, and he or they who are invested with it are the sovereign. Notice, he or they who are invested with it are the sovereign. And there is no definition on how many people are required to constitute a nation or state. This is the 1933 Montevideo Convention on the Rights and Duties of States that the U.S. has acceded to as a treaty. It's part of the treaty collection. A state is a person of international law, should possess the following qualifications: a permanent population, a defined territory, a government, and capacity to enter into relations with other states. And so that certainly the Republic of Texas qualifies in all of that.
Exactly. That's wonderful.
And all of the inhabitants of the territory properly included within and rightfully belonging to the Republic of Texas are entitled to the same protection of the law. And this is Article 9. The jurisdiction of states within the territory, within the limits of national territory, apply to all the inhabitants. Nationals and foreigners are under the same protection of the law, and the national authorities and the foreigners may not claim rights other or more extensive than those of the nationals. And that's Article 9 of the Montevideo Convention. So the state of Texas joined the Confederacy and Union. In 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union of 1781. They joined under the Articles of Confederation, as evidenced by the Act of Congress at 9 Stat 1 that still exists, as evidenced by House Joint Resolution, and still exists, as evidenced by House Joint Resolution 1, dated 29 December 1845, quote, the territory properly included within and rightfully belonging to the Republic of Texas was, quote, erected into a new state to be called the state of Texas, quote, on an equal footing with the original states in all respects whatever. And then also, quote, with a Republican form of government as found in the Act of Congress, December 29, 9 Stat 1. This is the preamble to the Act. Says, the The state of Texas admitted in the present session of Congress into the Confederacy and Union of the United States. And House Joint Resolution 1, dated 29 December 1845, 9 Stat 108, and says, whereas the Congress of the United States by joint resolution approved March 9th, the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the State of Texas with a Republican form of government. And then resolved and admitted into the Union on an equal footing with the original states in all respects, whatever. So the original states, they're talking about the Articles of Confederation. Okay, you got to understand that. That's what they're talking about. And that's why the law is different in Texas than it is in almost any other state. This theoretically should be the same as the original 13 states. So then it makes it the original 14 states. Anyways, because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under Articles of Confederation and Perpetual Union. Article 9 says Canada acceding to this confederation and joining in the measures of the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by 9 states, right? So they're talking, that sounds like a House Joint Resolution. See what I'm saying? Which means a House Joint Resolution, that's all that was needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas because the territory properly included within or rightfully belonged to the Republic of Texas was still there, which means the Republic of Texas is not replaced by the state of Texas, and the Republic of Texas still existed in abeyance or dormancy.
Yeah,
You see what I'm saying?
I see it.
It seems to the demandant that for the state of Texas to join the Confederacy under the Articles of Confederation and Perpetual Union 1781 with the House Joint Resolution is perfectly fine. But the preamble of the Act of Congress, December 29th, 1845 at 9 Stat 1 says Texas is admitted into the Confederacy and Union of the United States of America, which is also talking about the Union under the current Constitution, which was in place in 1845, and Article 4, Section 3, Clause 1 requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what happened. The state of Texas failed to replace the Republic of Texas, and the Republic of Texas was recognized by Andrew Jackson, still exists, and recognition is unconditional and irrevocable under Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934 at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. So this Constitution and the laws of the United States which will be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So it doesn't matter what's in anything in any state. In the year 1861, the southern states, including Texas, walked out of Congress, and Congress ceased to have a quorum to conduct business, could not conduct business. And on the 15th of April of 1861, the Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, which is a ceasefire only. All of those people are now dead, but there has never been a treaty of peace. The state of Texas was one of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. In the year 1863, Lincoln asked a Harvard law professor, Francis Lieber, to write the law of war for the U.S. Army, which became known as the Lieber Code, but was actually designated General Orders 100, all of which is now included in the United States Law of War Manual, which is now a book about 4 inches thick and is part of international law or the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effects and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. The fact that the Union Army invaded Galveston, Texas, means that we're under martial law. The military government and martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during a hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of the place or territory continues beyond the conclusion of peace is one of the conditions of the same. Because there's been no special proclamations by the Commander-in-Chief, the President of the United States, and there's been no Treaty of Peace to this date. Under a House Joint Resolution dated 29 December 1845 at 9 Stat 108, the state of Texas is required to have a Republican form of government. And it's impossible for a military government operating under martial law to be a Republican form of government, because a military government is a dictatorship, as evidenced by Article 3, General Orders 100 of the Lieber Code. And actually, there's a bunch of other articles that talk about it too.
Sure, when you talk about Article 3, that's say like an Article 3 court also?
No.
No, two different things.
Yeah, this is Article 3 of the Lieber Code. Article 3 of the court is Article 3 of the Constitution. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and the domestic administration and government in the occupied place or territory, and the substitution of military rule and force for the same, as well as the dictation, that's dictatorship, folks, of general laws as far as military necessity requires the suspension, substitution, or dictatorship. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. Now, they never, ever want you to know that you're under martial law. That's what the War of Independence was fought. And we're going to go into that here further on in this document. Because a Republican form of government requires law of the land, natural law, and common law, and political powers to be in the hands of we the people, and a symbolic military government called a democracy, with all state of Texas employees, including the wrongdoers named herein, being federal personnel, as required by the Pope's Roman Civil Codes, 5 U.S.C. Section 552 AA 13, which is anyone with a Social Security number. The term federal personnel means officers and employees of the government of the United States, member of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. That means anybody with a Social Security number. For the Pope's 1871 municipal corporation, civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell, 182 U.S. 244 in 1901, that is maintained by Congress outside and independently of that instrument, which is the Constitution. This is the dissenting opinion of Justice Marshall Harlan. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And the Pope's military dictatorship plenary power, because the boundaries of the District of Columbia expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And this is National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948. And through their plenary power nationally covers those citizens, even one of the several states, and so the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Therefore, the Pope's owned and operated United States has failed to provide a Republican form of government as required by Article 4, Section 4. The United States shall guarantee to every state in this union a Republican form of government, except that the Republic of Texas is the Republican form of government. After the war between the states and its armistice, many years have passed, and all of those involved on both sides are now dead. And the early 1990s, some of the people of Texas, after reviewing the Act of Congress 9 Stat 1 and the resolutions, House Joint Resolution 8, March 5th, 1845, 5 Stat 797, and House Joint Resolution 1, 29 December 1845, 9 Stat 108 of the U.S. Congress and other historical evidence, discovered that the state of Texas is a fictitious overlay over the Texas territory that is properly included within and rightfully belonging to the Republic of Texas, over the Republic of Texas, which is in abeyance or dormancy, and brought the Republic of Texas out of abeyance by organizing a provisional government of the Republic of Texas and peacefully held elections, and have been peacefully holding elections ever since, to peacefully provide common law remedies for the people of Texas. The Republic of Texas is a foreign government. The Republic of Texas is a group of men and women on the territory properly included within and rightfully belonging to the Republic of Texas, trying to peacefully bring common law remedies to the people of Texas as a Republican form of government, because the state of Texas is a military government operating exclusively under martial law as a military dictatorship in the District of Columbia and can never be a Republican form of government. Even though the demandant has resigned as a senator, the demandant can say with some authority, after being involved with the Republic of Texas government for almost 20 years, that the people of the Republic of Texas would very much like to enter into a treaty of peace with the United States to bring to an end the war between the states as far as Texas is concerned. We believe it would be good for everybody, and maybe other states formerly part of the Republic of the Confederate States of America would like to do the same. It would be very good to bring that dark chapter of our history to a final conclusion. Case dismissed for lack of jurisdiction in the year 1995. The Supreme Court of Texas dismissed case 95-1002 involving the people of the Republic of Texas for lack of jurisdiction. Styled in re, the people of the Republic of Texas by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District at Tal, evidencing that they know they have no authority over the people of the Republic of Texas. Right to self-determination and political status. The U.S. Congress and President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, and is now the supreme law of the land as a treaty under Article 6, Clause 2. And we, the people of the Republic of Texas, have the right to self-determination, the right to determine our own political status as Texas nationals for a Republican form of government, guaranteed under Article 4, Section 4, since the Pope's owned and operated United States has failed to do so. Martial law caused the War of Independence. The War of Independence was fought over the imposition of martial laws found in the Causes and Necessities for Taking Up Arms, issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. To supersede the course of common law and publish the order and use of the exercise of law martial, That's martial law, folks, as evidenced by the organic law, the Declaration of Independence, and as evidenced by the organic law, the Declaration of Independence, which is a list of grievances against King George. He's combined with others, the Pope, to subject us to a jurisdiction foreign to our Constitution, Roman canon law, and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses from the Pope. And King George even signed the definitive Treaty of Peace in 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, all of which evidences the true enemy being the Vatican, and the same things are happening in this case today. For all the foregoing reasons, the defendant hereby provides noticing he's challenging the constitutionality of Texas joining the Union in 1845 as a violation of this Constitution for the United States of America, Article 4, Section 3, Clause 1, which requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what happened, as evidenced by the Act of Congress, 29 December 1845 at 9 Stat 1, and in House Joint Resolution 1 dated 29 December 1845 at 9 Stat 108, the territory properly included within, and rightfully belonging to the Republic of Texas was erected into a new state to be called the state of Texas. That sounds like they're forming a state within a state. They're erecting. They use the same wording. They erected a state within a state. Anyways, and so I got in here that fails to be dead or lost at sea. I'm putting that in everything now. That fails to be dead or lost at sea. And so that's the notice of constitutional challenge. That's actually been filed.
That's a good, you did good on that one. That's really good.
So I've got another one. This is the another one for the minor estate. So, but let's, I want to,
I don't think they're gonna, well, we'll see what happens.
what?
They really can't even, technically, the Republic of Texas is over them
Oh, I know.
to even respond.
Well, no, actually, what I want to do is get a judge's ruling. And that's why I'm doing it as a constitutional challenge, because now they have to rule on it. They got to say you're right or you're wrong.
Okay.
You see what I'm saying? And so that's why I want to do it, because that's part of my lawsuit. If they say I'm right, then any lawsuit, any court case is about the little decisions. There's no judge going to make some big, huge decision. What you do is you start hitting them with these little decisions. Like for example, when I went and did a motion to quash the warrants, okay? I didn't do a motion to challenge jurisdiction, okay? I did a motion to quash the warrants, and I had good reasons why they were supposed to be quashed. But once those warrants were quashed, everything else fell away.
Right.
That's why they dismissed the whole thing and kicked us out of there.
Right.
But so you gotta.
You're getting steps.
That's right. You gotta hit them with the little things. They're not gonna make a big decision.
Yeah.
You gotta hit them with the little things, and this is a little one. And here's another little one. And plus, I have the Court of Appeals has responded in my case that I filed with the Court of Appeals. And they basically went along with everything else that was going on. I kind of half expected them to. And I think what happened is the Supreme Court probably called them up and told them that they had to respond. But that's okay. So now I've got 120 days to file a petition for writ of certiorari to the Supreme Court. And I've got most of it done, although I might have to I'll have to make some changes for sure. Anyways, so the bottom line is that I'm going to file a petition, so it's going to be a regular petition. It won't be an emergency one like I was doing. But I think they want this case, okay? But I'm going to set this case up so that even if they turn that case away, there'll be another one coming, okay? And that's why I'm doing this brief in support of a motion for a constitutional challenge. Right. So I need to make this text bigger because it's hard to read when it's this small. How's that? I think there's a delay, but I'm wondering how come. Oh, that's why. It's the wrong one. Okay. Right. That's why. So I'm trying to make it bigger because then people can see it on YouTube easier. Yeah, that's better. So that's what we're going to talk about next. Okay, and it's coming through on YouTube. So this is the brief, okay? So you file, what you do is, if you notice on the first one, there's a notice and then a brief you attach to it. You know, that's in the local rules that you have to do it that way. So anyway, so that's how I'm doing it. Anyway, so this is the brief. Pope's ecclesiastical city-states in Italy. The Pope was absolute monarch of a group of ecclesiastical city-states on the Italian peninsula. Roman or papal states stretch across the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast area. 17,822 square miles, population in 1833, 2,742,000. Capital Rome, population 153,000. Government and elective monarchy, the Pope for the time being the absolute sovereign with a consulting assembly of cardinals. And that's taken from Watterson's Encyclopedia of Commerce and Mercantile Law, 1863, page 582. And then Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. And that's Encyclopedia Britannica, volume 3, 1773. With ecclesiastical law being Roman law, and was also called canon law, municipal law, and civil law. The laws of the municipia, or dependent states. So this is taken from Encyclopedia Britannica. Civil or municipal law is that which every sovereign kingdom or nation has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. And canon law is a collection of ecclesiastical rules in the form of the civil. So canon, or body of canon law, collection of ecclesiastical rules, definitions, and constitutions. This law is modeled according to the form of the civil. So that's all tied together. It's all civil law. Roman law, civil law. This is Black's Law Dictionary.
Right. There is no criminal law.
So it's all Roman law. The civil or Roman and canon law, they're not perhaps to be deemed parts of our law. This is Encyclopedia Britannica, and it was written in Scotland. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the years 1870. The year prior to Congress's 1871 Ecclesiastical Municipal Corporation, that's 16 Stat 419. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when a 1946 Italian institutional referendum ended the monarchy, and that's taken from Wikipedia, and are now called Vatican City and the Holy See, and it continues to this day. And this is the Lateran Pact of 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes appertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. So the Pope's ecclesiastical Roman canon law, Sestike Ius, was brought into the United States with the Pope's 1871 Ecclesiastical Municipal Corporation at 16 Stat 419, because civil law, Roman law, and municipal law are convertible phrases, because municipal law was the law of the municipia or dependent papal ecclesiastical city-states. So in the year 1213, King John gave the kingdoms of England and Ireland to Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary under the definition of pope. And not long after this, by general excommunication to the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. With the concessions of England to the Pope, and you can look this up online. This is freely available online. I've had this for like decades. We will establish perpetual obligation. Concession will establish from the proper and special revenues of our aforesaid kingdoms for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter. The Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the kingdom of England, 300 for the kingdom of Ireland. And that's concessions of England to the Pope, 1213. Which means the Pope owns the kingdoms of England and Ireland, now known as United Kingdom, the Crown, and the City of London. Sestike V Act caused the War of Independence. The Pope's dependent city-state in the City of London, called the Crown, created the Sestike V Act of 1666, and this is Tomlin's Law Dictionary, 1835 edition. Yet still it is found difficult to set bounds to ecclesiastical ingenuity. That sounds like the Pope, folks. When they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That sounds like the Vatican. Thus distinguishing between the possession and the use being usufruct, okay? Got to think of it that way. Use means usufruct. And receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. Well, courts of equity are then still under the direction of the clergy. It's the Vatican. To be bound in conscience to account to a Sestike Ius for the rents and emoluments of the estate. Sestike usufruct. And that's taxes. They're talking about taxes there. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, usufructs and trusts. The foundation of modern conveyancing is still the foundation of modern conveyancing. Who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to a Sestike Ius for the rents and emoluments of the estate, which means the Pope's clergy were the judges in the ecclesiastical municipal law courts, which is what precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by a jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law of martial. It's martial law. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. That's dictatorship. And the organic law, the Declaration of Independence, shows it was listed as reasons for the Declaration of Independence from the Pope's tyrant, the Crown of England. He's combined with others who subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. They're talking about the Pope. For transporting us beyond seas to be tried for pretended offenses, that's the minor estate, imposing taxes on us without our consent, depriving us in many cases of benefits of trial by jury, taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. He's abdicated government here by declaring us out of his protection and waging war against us. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, the others is talking about the Pope, and the foreign jurisdiction is the Pope's ecclesiastical Roman civil law. And the preamble of the definitive Treaty of Peace of 1783 says King George was arch-treasurer and prince-elector of the Holy Roman Empire, evidencing that he's authorized to make peace on behalf of the Pope. The Pope's minor estate, the Pope's Sestica V Act of 1666 was brought into the United States with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be Sestica Jus, in Section 1617 and 31 Stat 1432, and now codified at 31 CFR 363.6, and the Pope's necromancy Sestica Jus, which use is usufruct, and people are presumed dead. At Chapter 3, absence of 7 years, 31 Stat 1230, where it says presumption of death. He shall be presumed dead in any case wherein his death shall come into question, unless proof shall be made he was alive within that time. The proved minor estate, Sestica usufruct, now codified at 31 CFR 363.6 and are unconstitutional because Article 1 an amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, Sestica Jus, which is a usufruct, which is now called the minor estate in 31 CFR 363.6, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And this is 31 CFR 363.6, part of it. Entity means the owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities in their treasury direct account. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of securities contained in his or her minor account. The Pope's pretended jurisdiction. Remember back here in the Declaration of Independence, it was talking about pretended offenses, pretended legislation. Well, what does that mean?
It means that
They're talking about pretended legislation and pretended offenses in the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. This is talking about the Pope's ecclesiastical Roman canon civil law. Canon law is the body of Roman ecclesiastical law relative to such matters that the church either has or pretends to have the proper jurisdiction over. That's Bouvier's Law Dictionary, 1856 edition, volume 2, page 8. Canon law, or body of canon law, collectively ecclesiastical rules, definitions, constitutions taken from the ancient councils and writings of the fathers of the church, ordinances of the popes, etc. This law is modeled according to the form of the civil and contained in 3 particular volumes. There's a lot of references in old law dictionaries to the Pope's pretended jurisdiction. Jesuits, this is Jacob A. New Law Dictionary, 1750 edition. Jesuits born in the king's dominions and ordained by the pretended jurisdiction of Rome. And this is Tomlin's Law Dictionary, 1835 edition. The oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. The Pope's sesticate use, minor estate, is a fiction of law, was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. That's Bouvier's Law Dictionary, 1856 edition. Volume 1, page 520. And the Pope's fictions of law are necromancy and satanic. And this is Deuteronomy 18:10 to 12. There shall not be found among you any that maketh his son or daughter to pass through the fire, or that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all these things are an abomination unto the Lord. Because of these abominations, the Lord thy God doth drive them out from before thee. And put you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Auction 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever of such district, not exceeding 10 miles square, as made by session of particular states, and the acceptance of Congress become the seat of government of the United States. Fictions of law were invented by the Roman praetors, derogate from law under ecclesiastical common law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. Fictions of law were invented by the Roman praetors, who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it, under the pretense of doing equity. Fiction is the resource of weakness, which in order to obtain its object, assumes as a fact what is known to be contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origins to the legislative usurpations of the bench. And that's actually quoted right here. A bill of attainder, bill of pains and penalties. The fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And that's taken from U.S. versus Lovett. Legislative act, no matter what their form, that apply either to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. U.S. Supreme Court. And a bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So the bill of attainder is death penalty. Because judges only hold office during good behavior, the judges both the Supreme and Inferior Court shall hold their offices during Inferior Court shall hold their offices during good behavior, Article 3, Section 1. And judges in bad behavior are engaged in fraud upon the court. And that's right here, fraud upon the court. Fraud upon the court is fraud which is directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influenced, or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. Gee, that sounds like that happens every day of the week here. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction. Remember, we're talking about in derogation of law up here. When the superior court, so it's familiar law that when special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc. Quad hoc is Latin, means for this proceeding only, a court of inferior or limited jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, A decision made in excess of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. They use fraud and a deception to assault people with a quasi-contract, which is a fake contract, a subset. In its origin, an action of tort, a subset was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. They just make this stuff up as they go along. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account. See, these are commercial terms, debt, account, case upon a bailment, warranty, bills of exchange, that's all commercial, and competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of a fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Pope's fiction of law or minor estate. Constructive quasi-contracts are based solely on the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia and through their plenary power nationally covers those citizens even in one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for a Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And Kavanaugh said, yes, you can. And because the plenary power is a dictatorship under the Pope's Roman civil law, plenary is full, complete in the courts of admiralty. It's plenary as a plenary power is a complete and absolute power to take action in a particular issue with no limitations. Plenary power, complete power over a particular area with no limitations. This term is often used to describe the commerce power of Congress under the Commerce Clause, Article 1, Section 8, Clause 3. Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without permission of Congress. And that's Legal Information Institute, which is Cornell Law School. Everything changed. The Pope's private bar guild. Everything changed for the bar with the Bar Treaty of 1947. The Pope's clergy operate their ecclesiastical Roman civil law courts with a private bar guild, the bar being an acronym which stands for British Accredited Regency. Regency is the operative jurisdiction of a region or body of regents, a government by authority of regents, the period during which a region or body of regents governs. That's Black's Law Dictionary, 8th edition. Because the Pope's private bar guild clergy members are appointed by Inns of Court. Inns of Court, certain private unincorporated associations in the nature of collegiate houses located in London, that's City of London, invested with the exclusive privilege of calling men to the bar, which is located in the Pope's dependent city-state located in the City of London, originally called the Kingdoms of England and Ireland, now called the United Kingdom and the Crown, since the concessions of England to the Pope, 1213, which means all private bar guild members are foreign agents of the Pope, which is why they're here under the Pope's civil laws. And Congress Foundation, actually, should put a Congress's foundation of the Federal Bar Association under the Code of Law for the Pope's District of Columbia, now known as Title 35 USC 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, 59 Stat 669. The demandant has filed bar grievances against 98 of the Pope's private bar guilds, some more than once, and they've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were all dismissed again. The demandants filed judicial complaints against more than 50 judges with the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. There's two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The Pope now owns and operates the 1871 Municipal Corporation. The Pope now owns and operates the bankrupt 1871 Ecclesiastical Municipal Corporation of 16 Stat 419, because when any corporation goes bankrupt, it gets seized by its creditors, as evidenced by the Roman Achaea military staff that's carried in battle by all Roman commands and planted on all conquered nations, that's sitting on the right side of the speaker's podium, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is why, as Speaker of the House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers, all of which evidences the fact that the 1871 Ecclesiastical Municipal Corporation at 16 Stat 419, currently operating in the District of Columbia, is the Pope's dependent city-state. See the image below. And the Vatican's Pope Francis recently issued an apostolic letter about the jurisdiction of judicial authorities of Vatican city-state in criminal matters that talks about concurrent jurisdiction in other states, which means other papal states like the District of Columbia and the City of London and the United Kingdom Crown. And it said there, paragraph 5, when the same matters are prosecuted in other states, the provision in force in Vatican City-State on concurrent jurisdiction shall apply, which is talking about the District of Columbia and the City of London, which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, 31 CFR 363.6, fiction of law, and the Pope's fictitious quasi-contract. And there's an image of the Speaker's podium in the U.S. House of Representatives, and there's your Roman Achaea military staff, and these are two Roman fascias on the wall. And the Vatican's Pope Francis came and addressed his own and operated Congress on 24 September 2015, and the Pope's satanic private bar guild clergy members are assaulting people like the demandant with their ecclesiastical fiction of law, minor estate, sestike usufruct trust, necromancy, with presumptions of jurisdiction, presumptions of the office of trustee, because the sestike usufruct minor estate is a type of trust, and presumptions of suretyship. The demandant has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, exercising constitutionally protected rights to seek a redress of grievance and exhaust administrative remedies, which is why they've targeted the demandant with their targetedjustice.com website agenda. Conclusion: the Pope's 1871 Ecclesiastical Municipal Corporation at 16 Stat 419 operating in the District of Columbia is unconstitutional, as well as the Pope's minor estate, 31 CFR 363.6, and the Pope's private bar guild, because they're all violations of Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they are laws respecting the Pope and the Vatican and the Holy See, and they are subjecting the demandant and all the people are dealing with to their satanic religious ceremony with their fake ecclesiastical Roman law court cases, with their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking. And that's the end of it. And notice I said before that fails to be dead or lost at sea. I added in that fails to be a surety or accommodation party for the Pope's minor estate. I added that in too. And that's also in here. That fails to be a surety for the Pope's minor estate. So anyways, so that's this one I haven't filed yet. I've been tweaking it and stuff, and so I think it's pretty well done. I could file it today. If I make it down to the court, I might file it today. We'll see. So let's see what's going on YouTube. So anyways, so now, let's see, this has been going on for an hour. I also have a notice of objection to the electronic filing. This one's been filed. And I did this before, and it was crickets. I never heard another word about electronic filing. When you first open a court case, they give you this document that says that you have to do electronic filing. And I've had cases dismissed because I didn't do electronic filing. So I respond now. And if you look right here, it's been filed. It was filed yesterday. And so this says, notice of objection to the District of Columbia electronic filing. The demandant will gladly do electronic filing when this court provides her statutory and delegated authority to compel the demandant to do the electronic filing, and when this court provides an order signed by a judge acting in his official capacity with a court seal on it that the demandant apply for and get a social security number, get 2 forms of government issued identification, then get a bank account, and then get a debit card for their electronic filing, all of which falls under the Pope's Roman canon law. And this court, and C, provides a Article 4 Amendment warrant signed by a judge acting in his official capacity with the court seal that orders the demandant to disclose all or part of a social security number, disclose a debit card number, disclose a name, disclose an address, disclose a date of birth, disclose 2 forms of government identification, disclose anything else to the electronic filing system that's required, calling out specifically what has to be disclosed as required by Article 4 Amendment for the social security number, the bank account, and their electronic filing. And that's it. That's pretty short. That's 2 pages. 3 pages with the certificate of service. So that was already filed, so I doubt I'm going to hear another word about that. And then we've got in the car, where is it? A notice of objection to the District of Columbia Informa, because I went down there to get some summonses. They won't give you summonses until you pay the filing fee. And so I'm hoping this will resolve that issue. Now, I did this before, but I also paid the filing fee before, and the judge actually responded to this, and he responded it by saying that I had already paid the filing fee. So I think I hit a nerve. I think this is going to work. But if worse comes to worse, I'll do Ken's method. I'll send him 400 grains of long grain rice. So I've got a backup plan anyways. Notice of objection to the District of Columbia Informa Pauperis interrogatory, because that's what it is. You got to understand, that's a questionnaire, and any questionnaire is an interrogatory. They're wanting to know all sorts of information. It's none of their damn business. So the demandant will gradually complete the Informa Pauperis interrogatory when this court provides their statutory and delegated authority to compel the demandant to complete the Informa Pauperis interrogatory, and this court provides an order signed by a judge acting in his official capacity with a court seal on it, ordering the demandant to apply for and get a social security number, get 2 forms of government issued identification, then get bank accounts, call the girl to whom he is joined in holy matrimony a spouse, and call his property assets, and call his sons and daughters, children, and dependents, call the compensation for labor, call his source of compensation for labor, his employer, call his private automobile a motor vehicle, call his compensation for labor gross monthly pay and income, call the land he owns an asset, call his traveling transportation, call his home a legal resident, call the money he spends expenses for their Informa Pauperis interrogatory, all of which falls under the Pope's Roman canon law, and this court provides an Article 4 Amendment warrant signed by a judge acting in his official capacity with a court seal that orders the demandant to disclose all or part of the social security number, disclose financial institutions, disclose income, disclose spouse income, disclose gifts, disclose spouse gifts, disclose retirement income, disclose other income, disclose the demandant's age, disclose employment history, disclose spouse employment history, disclose employer, disclose employer address, disclose expenses, disclose assets, disclose a legal residence, and disclose anything else that's required to be disclosed. and calling out specifically what is required to be disclosed as required by Article 4 Amendment for the forum of pauperis interrogatory and signed and sealed. And so I think this is going to destroy their narrative. We'll see. That's all I can say. And so there's the certificate of service. I've got this in the car. I'm gonna take that down and file it today if I get down there today. Anyways, so does anybody have any questions?
You think Jason? That's pretty good. That last thing on words. It's all about words.
It is. Everything's about the words.
Because we don't have any income.
Yeah, income is for judges, right?
But it's corporate revenues. You know? What do you think, Bill? Any questions about anything?
Good job.
You got
Just great job.
Can you think of any other words that you can add to the judges? Because the financial statement is only for corporations.
They have, yeah, right. So anyways, last time, the one that I did for the electronic filing, it was crickets after it. I never ever heard another word. I went down there and filed all the time. I mailed stuff into them all the time. Never a problem. Never heard a peep out of them. Everything I did in the last court case was through the mail, or I went and filed it down there. And so I think this is going to work. But if worse comes to worse, I'll do the long grain rice method.
Yeah.
And be the next one.
They have the sign when you go up to the clerk's office in the federal building. They won't take Federal Reserve notes anymore.
Yeah, isn't that interesting, eh? Yeah, you can't pay a Federal Reserve notes.
And it's a federal building.
Wow. What are they
Well, you know,
accepting?
as I heard last night, they're getting rid of the IRS whole thing.
Well, I think well, they want to get rid of the Federal Reserve, but the IRS is just the accountants.
IRS is specifically, and Social Security, all of it.
I think what I heard.
Tariffs are going to take place.
Yeah, that's what I heard.
We're not going to have any more income tax. We're going to only charge the foreign people.
So what are they
And
accepting?
They're going to have an external revenue service.
That's right.
What were you saying, Lulu?
What are they accepting as payment?
Debit card.
Yeah, they actually give the local address of the post office, the money order.
You'll still have a Social Security number, but not a card. The card is no longer going to exist.
I don't know about that. Why would you need it, even the number? But anyways, who
Well,
knows?
yeah, but okay, that is a number is what they're going to do right now. Right now, today, they're not going to have a Social Security card.
I think they're gonna.
They have the number, but they're getting rid of the number when they get the tariff process.
I guess we'll see how that all plays out. I think that it's gonna be in phases. They can't just do it all at once. But right now, what I'm hearing is that there's gonna be a proclamation here pretty soon of a national emergency because of election theft, and they're going to come out with all paper ballots, no electronic machines at all, and very little mail-in ballots allowed. They're only under extreme circumstances, and everybody's got to re-register. The voting lists are completely unreliable, and everybody's got to start new voter lists. Everybody's got to re-register. So they're going to have to do that pretty soon to get it all in place for like this coming fall, which is a year away now, less than a year. So I guess we'll see how it all plays out. But so this is stuff that I filed or I'm gonna file in my case. We'll see. I think I won't have to pay the filing fee. I'm not worried about paying the filing fee because I'll do Ken's long grain rice method if worse comes to worse.
Is your intention of filing this to get the Republic of Texas recognized as its own government?
That would be really good. Okay. I told the chief of police in Colleyville, I told them that I'm a protected person under international law, and I have diplomatic immunity for life. And once I told them that, after that, they flat out told me just make sure we can. I had a cover on my license plate, and it was kind of hard to see. And they flat out told me, take that cover off so we can see your plate, and we won't stop you anymore. I mean, they told Darren that, I think, didn't they, Darren?
Yeah, we just said we can't see the numbers.
Yeah.
We need to.
Yeah. So they haven't stopped me since. Not with that car. Now other ones have, and so ideally, that's what I want them to. Like, I'm not a senator anymore, but I would like to be able to claim Texas national. I'd like it to be in their system that I'm a Texas national, and I have diplomatic immunity. That's really what I'd like to have, in their whole system. You know what I mean? Everywhere. And so then I could live in Arizona, because once you have diplomatic immunity, you got it no matter where. And also it would help the people of the Republic of Texas too. You know, it really jerks my chain that they're a bunch of cowards and don't want to help me with what's going on. But you know, whatever. I'm going to have to deal with it, so I'm dealing with it. And so you know,
They'd feel more relaxed if they would recognize Republic of Texas. You know.
Sorry?
Well, a lot of people, like, I don't mention names, they won't come to our aid when I was calling.
I know.
For help.
I know. And so, yeah, if the government actually comes out and says and recognize, well, they already recognized it. Okay, they cannot take it back.
Right.
And so all they have to do is reaffirm it somehow, or better yet, let's make a treaty of peace. I think that would be wonderful, because that would get them off the hook too.
Right, and also end the Civil War.
Well, as far as Texas is concerned, and it would tell other states, like I've heard there's people in Tennessee and Georgia that would like to do the same thing. And so that would if we could bring that to a conclusion, you know, that would be wonderful too. And so I mean, there's a lot of things that
because we need a Republican form of government.
Well, we're entitled to it, and the state of Texas is not a Republican form of government. It can never be a Republican form of government. Yes, Bill?
Yeah. It all started with canonization. The canon. The canon is the original rule of law.
Sabat?
It was established by the people, the man, not by God. They say it's by God. Everybody says it's by, but it's all done by man. And this is the big problem: is man is getting so, like I've always said, stupid.
Right.
That man is not going to be able to do it. Look at the people, the millennials. Now you all know, you all are part of the millennials, and so therefore not a problem for you guys. But believe me, it's a big problem, and that's what's happening to our country right now, where it is not going to exist at all. There won't be a Republic of Texas. There won't be anything.
What will it be like, you think, Bill?
I think it will be absolutely, I know exactly what it will be. It will be nothing. It will be corruption. There will be no law, because the people aren't smart enough to figure it out. We figured it out 50 years ago. And that's when it started going down 50 years ago. So, and before that even. It's going to change dramatically. Into what exactly, I'm not sure right now. You could also say the 3-Eye Atlas is part of coming in to take over. Or it might not be anything to it, 3-Eye Atlas. It might be a big joke. But It's irrelevant what it is.
Every man for themselves.
Well, it's going to be different, and we can't say what it's going to be any more than we can say what Three-Eye Atlas is. We can't say what it is, if that's corrupt or if that's not real, or it seems to be like it will be taking over. We won't have to worry about anything.
Well, that was actually, have you ever heard of Dr. Michio Kaku?
No.
He's a Asian physicist. He's a brilliant guy. He was on Coast to Coast in the 90s, Coast to Coast AM. Anyways, he says that Three-Eye Atlas made some transmissions to deep space. They used our satellites to make the transmissions to deep space, and the transmissions were answered within hours. And there's supposed to be 17 different civilizations that are on the way here, and that's what he says, which is very interesting. He said that because he's a physicist, and he said that the fact what they did destroys our understanding of physics, and he said that he puts us into he said it basically destroys our understanding of physics. And we need to go.
That's what my books are about.
Is that right?
It's about man is no longer able, because every 2/3 of this book is about that.
Right.
Is about man is not able to handle it. And I've got from the Royal Observatory, Greenwich, England, and many other letters in my book that are just exactly about that.
So he basically says that there's 17. He said that because they went and transmitted signals that went to other parts of the galaxy, hundreds of light years away,
right?
And he said that it destroyed our understanding of the limitations of light speed. He said that the signals went there way beyond the speed of light.
My other book, The Theory of Non-Relativity, is about that Einstein is becoming popular again now. But again, it's only because the people don't understand that he's not what they think he is.
Yeah, there's a lot of people that are saying what you're saying.
And it's real. Back in 2000, it was on PBS, Channel 13. They had a big deal about Einstein. And they got part of it right, but I was also on my Theory of Non-Relativity at the same time working on that. And I read the same book PBS read, and was quoting various things about Einstein, but they left so much of it out that it was what went into my book, what they left out. And it's amazing how all that is coming together right now, today. And there's going to be a lot happening, and fortunately we don't have a clue, because but when it happens, don't be surprised.
Well, I think that's why I read that thing by Cliff High, because I think everything that's happening right now is all.
Well, it's hype right now.
It is. There's huge things happening right now, and Trump is going to get rid of the Federal Reserve, and there's just huge things happening. What I think is going to happen is there's a good chance the United States is going to break up.
I think so.
So
I think there's no doubt about it.
We'll see how that all plays out.
And I think what it will be is Three-Eye Atlas will point us into the right direction. This is where the change is going to happen.
Well,
that's part of it.
They said that there's you ought to watch the video. There's a video with Dr. Michio Kaku on Brighteon, and I went and downloaded it. I would recommend you go there and just look him up and watch his video, because
I've seen many of his videos. I've seen all of it.
Okay, so you've seen it. Anyways, okay, so we're about done with what I was going to talk about. I'm going to end the live stream.
Yeah, we're going to do a little skit.
Okay, that's fine. So I'm going to go ahead and end the live stream. Thanks everybody for watching, and we'll see you next week, if not sooner.